Hello, friends, and welcome back to a scholarly edition of the Liberty Weekly podcast. This is episode 46, entitled The Truth About Warren v. District of Columbia. I'm your host, as always, Patrick McFarlane, and for those of you viewing on the YouTube channel, which is becoming the premier way to view the Liberty Weekly podcast, for all of you listeners of the podcast, I really would check out our YouTube channel at youtube.com/Liberty Weekly. As you can see, I'm taking things a little more seriously. I am dressed up a little bit, if you want to check that out. But I'm doing so because this is a very serious topic, and I would like to be taken seriously in regards to things such as this. And for the scholarly episodes of the podcast, I wanted to make a few announcements. Also, I've been in touch with Mike Morris of the Front Range Voluntaryists about my domestic violence paper that I'm also going to be presenting on the podcast here in the coming weeks. But we're in talks about possibly publishing that paper, or at least the working draft of it right now. I know that I have plans to send it to maybe a few libertarian scholars, such as perhaps Walter Block, who's been in touch and appearing on the Actual Anarchy podcast once in a while for their Anarchy in Action series. So I'm very excited about that. I'm also, I think, going to make kind of a concerted effort to niche down here with the podcast and do more legal focused things. One thing that I wanted to do was, I had an idea that maybe members of the audience could send me court cases that they're interested in or that they want me to take a look at, and I could perhaps do a brief on the opinion if I could find it on Lexis. And I think that would be really interesting, and I think also very helpful, because I don't really think that anyone is doing that that I know of in our sphere, in the voluntarist sphere. So that being said, I'm excited for those prospects, but I also want to dive in to the podcast here today before too long. So Warren v. District of Columbia is an oft-cited case from people in our spheres. Basically, the general rule, or what you'll hear, people will cite it in order to support the fact that there is a general rule that the police do not own a specific duty. They do not owe a specific duty to individual members of the public. And I remember hearing that, as I've alluded to in the podcast before. I remembered hearing that a few months ago. I never bothered to take a look at the opinion, but when I heard that, I was like, well, that doesn't sound right. But having studied the opinion and having thought a bit about it, I think it makes perfect sense. That doesn't mean I agree with it or that it's right, but it does make perfect sense, and it is right within the traditional legal sphere. So, just to get into the procedural posture of what this case is and what this case is about, this case is a appellate court decision from the D.C. Court of Appeals. I know that D.C. is kind of a unique animal within our legal system. I don't think that D.C. does not have a Supreme Court, the D.C. itself. So usually the way our legal system works, the state courts have their own system, and then the federal courts have their own jurisdiction and their own system. So you'll have a federal district court, they have a district court of appeals, and then they appeal to the Supreme Court, obviously, and the states have their own systems, whereas it's state district court, or I think in Wisconsin it's the circuit court. And then you have the appellate courts within the state, and then you also have the state Supreme Court. But D.C. is a unique animal, and from my understanding from reading this opinion, D.C. has their superior court, which is the district court, and then they also have the court where this decision came from, which is the the District of Columbia Court of Appeals, and that is the court of last resort, the final say within things falling within the D.C. jurisdiction as if it was a state. So this court case started out as there were two plaintiffs in this case. It's a civil action suing the city. Let's see. I believe it was the city, the municipality, and also the police department within D.C. But there were appellants Carolyn Warren, Miriam Douglas, and Joan Taliaferro on one case, and then in a different case was the appellant Wilfred Nicol, I believe it is. So they sued the District of Columbia and individual members of the Metropolitan Police Department for negligent failure to provide adequate police services. And by the way, I'm reading from the decision here that I got through my means, where a lot of attorneys, they have subscription service to like Westlaw or LexisNexis. This is mine. Unfortunately, I can't link to it in a way that you could access it, but you can find the opinion online. So I will link to that in the show notes page, but I'll be quoting heavily from it, and I would definitely urge all my listeners to download the opinion and read it for yourself, because honestly, there's a lot of things that will make you very angry in this opinion and that will make you very frustrated. So the procedural history of the case is that the case was thrown out in the district court level, the trial level, under a 12b6 motion, which is a failure to grant a claim upon which relief can be granted. And that is just basically saying, I mean, it's pretty self-explanatory. It's saying, well, this isn't a claim that we can grant any kind of relief for. There was, I think, a preliminary finding by this court. So it was appealed by the plaintiffs, the joint plaintiffs, and there was, I think, some preliminary findings. It says, in a split decision in a 3-judge division of this court, it determined that appellants Warren, Taliaferro, and Nicol were owed a special duty of care by the police department and reversed the trial court rulings. That was a preliminary court finding. However, at this level, they overturned that in the final decision from this court and found that neither of the appellants fit within the class of persons to whom a special duty was owed, and affirmed the lower court's ruling dismissing the complaint. So the facts in this case are very, very disturbing, actually. And so, like I said, there were two groups of plaintiffs in this case. One of the case, there were 3 plaintiffs in the appeal number 79-6. 3 of them were Warren, Taliaferro, and Douglas. The 3 of them lived in a rooming house, and they fell asleep. And in the early morning hours, the home was invaded by 2 gentlemen. Well, not gentlemen, as we'll see. But it says here in the opinion, the women were awakened by the sound of the back door being broken down by 2 men later identified as Marvin Kent and James Morse. The men entered Douglas's second room floor, where Kent forced Douglas to sodomize him and Morse raped her. Quoting from the opinion here, like I said, the facts are very brutal. And so when Douglas was being raped by the 2 men, Warren and Taliaferro heard her crying out, and they were in the floor below. Warren telephoned the police, told the officer on duty that the house was being burglarized, and requested immediate assistance. The department employee told her to remain quiet and assured her that police assistance would be dispatched promptly. Warren's call was received at Metropolitan Police Department headquarters at 6:23 a.m. and was recorded as a burglary in process. So 3 minutes later, at 6:26 a.m., a call was dispatched to officers on the street as a Code 2 assignment, although calls of crime in progress should be given priority and designated as Code 1. So that's the first mistake that the police department made in handling this case. 4 police cruisers responded to the broadcast, 3 to the Lamont Street address and 1 to another address to investigate a possible suspect to the call. Meanwhile, Warren and Taliaferro, who had called the police, crawled from their window onto an adjoining roof and waited for the police to arrive. They crawled there hoping that they would be safe from the assailants. While there, they saw 1 policeman drive through the alley behind their house and proceed to the front of the residence without stopping, leaning out of the window, or getting out of the car to check the back entrance of the house. A second officer apparently knocked on the front door of the residence, but left when he received no answer. The 3 officers departed the scene at 6:33 a.m., 5 minutes after they arrived. Warren and Taliaferro crawled back inside their room. They again heard Douglas's continuing screams, again called the police, told the officer that the intruders had entered the home, and requested immediate assistance. Once again, the police officer assured them that a police officer assured them that help was on the way. The second call was received at 6:42 a.m. and recorded merely as an investigate the trouble call. It was never dispatched to any police officers. Believing the police might be in the house, Warren and Taliaferro called down to Douglas, thereby alerting Kent to their presence, the assailant. Kent and Morse then forced all three women at knife point to accompany them to Kent's apartment. For the next 14 hours, the women were held captive, raped, robbed, beaten, forced to commit sexual acts upon each other, and made to submit to the sexual demands of Kent and Morse. And all this is because, excuse me, I'm going to take a drink of water here, but all of this is because the police failed to investigate the crime. So, the appellants took a negligence claim, saying that the police failed to act with due diligence. First, while they claimed that the dispatcher failed to forward the 623 call with a proper degree of urgency, they also claimed that the responding officer's failure to follow standard police investigative procedures, specifically their failure to check the rear entrance and position themselves properly near the doors and windows to ascertain whether there was any activity inside, and they also claimed that the dispatcher's failure to dispatch the 6:42 a.m. call was also negligent. So that is the first claim, the facts from the first claim. The second claim is just a single person, Nickel, that I mentioned before. This happened on April 30th, 1978 at approximately 11:30 p.m. Nickel stopped his car for a red light at the intersection of Missouri Avenue and 16th Street, Northwest. Unknown occupants in a vehicle directly behind Appellant struck his car in the rear several times and then proceeded to beat Appellant about the face and head, breaking his jaw. A Metropolitan Police Department officer arrived at the scene. In response to the officer's direction, Appellant's companion ceased any further efforts to obtain identification information of the assailants. So this part of the opinion is actually kind of awkwardly worded, but I think what they're saying is that the officers arrived and instructed the passenger that was in the vehicle with Nickel not to tell him or to try and observe or remember who the assailants were. It was a little confusing, but when the officer then failed to get the information, so I think maybe the passenger tried to describe the assailant to the officer, and the officer would not pay attention or told them to stop talking or something. So when the officer then failed to get the information, Nickel was then unable to institute legal action against his assailants because the policeman wouldn't listen to his identifying information. And so that's basically what the second set of facts is. So it still is an unfortunate set of facts, but not nearly within the degree of, the three appellants or the three plaintiffs from the other action who were brutally raped and tortured. But I mean, Nickel still had his face beat in, and he couldn't take any steps to try and confront the assailant because the police officer wouldn't take the identifying information. So the trial court judges, and in the opinion, Warren v. District of Columbia, they quote the decision from the trial court because they agree with it. But the trial court judge said, and here's the kicker where it gets interesting for our interests, he said, the fundamental principle that a government and its agents are under no general duty to provide public services such as police protection to any particular individual citizen. And he that was the quote to say that the district court Judge Hannon based his decision on that quote. He can this opinion continues to say, the duty to provide public services is owed to the public at large, and absent a special relationship between the police and an individual, no specific legal duty exists. So, based on that decision, they held that's why they threw out the lower court decision. And they're saying basically the fact that just because the police were responding to the event, that wasn't enough to create a special duty. So in both instances in the district court, the judge ruled that there was no specific legal duty that existed. And they based this decision off of the common law decisions that existed prior to this decision, a lot of them within other jurisdictions like Los Angeles and New York, and a lot of these fact patterns are equally as frustrating. One of them was a verbal statement by a police officer to an injured motorcyclist, promising the injured motorcyclist that he would obtain the name and the contact information of the motorist who struck him. This police officer made the promise and then failed to carry out and act on that promise and uphold his promise. The court in that case ruled that did not create a special legal duty for him to do so. So the motorcyclist was just out of luck. Another one was a police officer investigated a vehicle accident where the pedestrian was a minor child, and they're saying that the investigation of the accident did not create a special duty to the child's parents, who were then unsuccessful in their attempt to recover damages because the police failed to identify the drivers of the other vehicle. And that case was Jackson v. Heyman, and the other one was Falco v. City of New York. So that is the beginning of the decision, and they'll rehash and reassert those. Later in the decision, they reassert the principle that police only owe a general duty to the public at large and not to specific individuals. And they call this a uniformly accepted rule that rests upon the fundamental principle that a government and its agents are under no general duty to provide public services such as police protection to any particular individual citizen. And that language comes from Turner v. United States, 248 U.S. 354. And this is just a general quote that shows their reasoning. A publicly maintained police force constitutes a basic governmental service provided to benefit the community at large by promoting public peace, safety, and good order. The extent and quality of police protection afforded to the community necessarily depends upon the availability of public resources and upon legislative or administrative determinations concerning allocation of those resources. The public, through its representative officials, recruits, trains, maintains, and disciplines its police force and determines the manner in which personnel are deployed. At any given time, publicly furnished police protection may accrue to the personal benefit of individual citizens, but at all times the needs and interests of the community at large predominate. Private resources and needs have little direct effect upon the nature of police services provided to the public. Accordingly, courts have without exception concluded that when a municipality or other governmental entity undertakes to furnish police services, it assumes a duty only to the public at large and not to individual members of the community, which really sucks for everyone because the police maintain a monopoly over policing, and without their help, we have no one else to turn to because of that monopoly, and there are not sufficient private security firms that can step in and overtake this burden. But I've always said, and I've alluded to this in the podcast before, that this decision absolutely makes sense because in our Western legal tradition, we do not impose liability on someone who has undertaken no duty. And that's not to say that the police in this instance haven't undertaken a duty, but that if we were to rule that they had undertaken a duty to protect each and every single one of us, as is articulated later in this opinion, and I'll get to later, they would be so swamped with litigation because they do such a terrible job at what they do. And I think it makes a lot of sense. So in my torts class, one thing we talked about was how maybe in Europe they would impose a duty upon someone who was walking past a child drowning face down in a swimming pool, right? So this was the analogy that my professor used. So you're walking down a sidewalk, and in the front yard there's a child who's face down in a swimming pool, obviously not responding, maybe trying to swim or drowning or something. In the West, if you just walked on by and let that child drown, we would not jail you for not acting. That would be a form of tyranny. because you haven't undertaken the duty, you don't owe anything to that child. Maybe you have a moral obligation, but legally speaking, we would not jail you for not acting. In this specific instance, and I don't agree with this decision. I mean, it makes sense as a matter of law, but in that instance, it is non-action, and we get into this, but this is negative negligence, whereas the police failed to act. It's not like it's a positive situation, whereas, and what's alluded to in the decision here, whereas if a police officer was driving negligently and struck someone, or discharging a firearm negligently and struck someone, that would be something we would hold them personally liable for, whereas non-action or failure to do something, you know, to the degree that they should have, is not something legally liable. And that actually is a foundation of our Western tradition here. But they're talking about specific cases. They mention specific cases in which they have not held liability. One of them, in most often what comes up, is when the police fail to put down a riot, or when they fail to maintain public order and a shopkeeper is damaged or something by the mob that is looting and stuff like that. The police are very conveniently also not held liable for those damages for failing to maintain public order. And this was a specific case in Westminster in D.C. There was a riot, and they talk about that case, Westminster Investing Corp v. G.C. Murphy Co. And I'm not going to include the full site. You can find it if you look at the opinion. As to all these fact patterns, you can find them in the opinion. There was another case where a delivery boy had to make some deliveries in a bad neighborhood. So he asked the police for help to protect him, and they wouldn't do it. So he was attacked and beat up, and so he sued. And the court said, "Oh, sorry, there was no duty there to protect you." There was another one where a police officer observed two intoxicated people leaving a store and driving away, two vehicles, I believe it was, and he watched them swerving, had reasonable suspicion that criminal activity was afoot, and failed to stop the cars, while the two cars ended up hitting a van holding 6 passengers, and 5 of them died. And the court said that there was, no recourse for you there, that the police officer failed to stop these 2 drunk drivers. And like I said, these fact patterns are very infuriating. But here are some instances where the courts have held a duty, a specific individual duty. One is police informants. So when someone will snitch on other people, the police officers will make an offer to, for legal help or something like that. But when people snitch and they get beat up for doing so, the courts, or killed for doing so, the courts have found that the police owed a duty of protection to informants. Other one was a police officer was investigating a traffic accident and led a plaintiff into the middle of the highway, where the plaintiff was then struck by another car. So that's an instance where the police were held liable. Like I said, because that was an officer's affirmative conduct. Whereas they make the distinction in the Warren v. D.C. case that this was negative conduct. In negative as a pun, also being bad, but also signifying non-action on behalf of the police officers. Here was another one where a parole officer was dealing with a foster family, and the parole officer undertook a special duty to the foster family, but failed to disclose the fact that a child that they were getting was very violent and had actually beat people up in the past. And the foster child beat the foster parents up, and the court imposed a duty there. There was also another one where a governmental mental hospital was releasing a patient to his family. Let's see here. I'll just read the language. The United States Court of Appeals for the District of Columbia recognized a similar special relationship between a governmental mental hospital and the family of a violent assaultive patient who the hospital planned to discharge and who the hospital knew had previously attacked family members. And so they let the mental patient out, and the patient attacked the family members. So they were held liable there. And so then they kind of addressed the plaintiff's arguments in this case, Warren and Teofaleros, and they explained why it was a negative non-action on behalf of the police, on behalf of the responding police officers. And then they kind of talk about another case that was very irritating or frustrating to read, that there was and this actually, I wish that I had found this for my domestic violence paper, because this really would have helped me out. But there was a woman who was being abused, and she received a, quote, last chance threat from her abuser, saying that, if she didn't do this action, he was going to come kill her or beat her up. But she called the police to say, hey, he's threatening me, he's going to do something, and the police did nothing. And the following day, a hired thug from her abuser showed up and threw lye in her face. And the court in that case held that the plaintiff's pleas for help did not create a special relationship between herself and the police and could not serve on the basis of liability. There was another case where the police were held to be not liable, where a store owner arranged in a burglar alarm to directly contact the police station in this county, and he was burglarized, and the burglar alarm went off, and the police didn't do anything about it, and his whole store was robbed. And so the courts also held, even any alarm, no matter how this is a quote from it, an alert from an alarm, irrespective of how it was transmitted, is no more than a complaint that a crime has been or is being committed. So, like I said, this opinion is wrought with very, very frustrating fact patterns. After they go through all those, they address the arguments, and they kind of say, well, no, this is still a negative situation where the police didn't do something, and not a case where they did do something and were just negligent. And then the court cites Judge Cardozo's opinion from H.R. Mooch Co. Incorporated v. Let's see if I can read that. I'm supposed to get glasses. They haven't come in yet, so I'll look even more lawyerly, perhaps, hopefully. So it's H.R. Mooch Co. Incorporated v. Rensselaer Water Co. That's very hard to pronounce. But this is a 1928 case where Judge Cardozo articulates exactly what I was talking about before, where in our Western legal tradition, we don't impose duties upon people for not acting. So the fact pattern in this case was, the Mooch case was, I'll just read from Judge Cardozo's opinion. He says, "It is ancient learning that one who assumes to act, even though gratuitously, may thereby become subject to the duty of acting carefully if he acts at all. The hand once set to a task may not always be withdrawn with impunity, though liability would fail if it had never been applied at all. If conduct has gone forward to such a stage that inaction would commonly result, not negatively merely in withholding a benefit, but positively or actively in working an injury, there exists a relation out of which arises a duty to go forward." So he's saying that if you undertake a duty, if you're just a volunteer and you undertake a duty, then you have a duty to perform that to a reasonable degree. But if you're just a bystander walking past and you are inactive, then we're not going to impose liability on you. You can't be imposed liability for withholding a benefit. And then there's a bit about volunteer liability. So the opinion says, moreover, volunteer liability is premised in large part upon the assumption that the volunteer is free to assess each rescue situation, weigh the risks involved, and determine whether to shoulder the obligation or leave it to someone else. Police officers clearly are not in a position to make such choices on a case-by-case basis, and it would be absurd to presume that an individual assumes a permanent volunteer status when he becomes a police officer. Again, in the words of Judge Cardozo, an intention to assume an obligation of indefinite extension to every member of the public is seen to be the more improbable when we recall the crushing burden that the obligation would impose. A promisor will not be deemed to have had in mind the assumption of a risk so overwhelming for any trivial reward. So this court concludes that thought by saying that the difference is between ordinary negligence on one hand and a novel sort of professional malpractice on the other. A person does not, by becoming a police officer, insulate himself from any of the basic duties which everyone owes to other people, but neither does he assume any greater obligation to others individually. So then the court kind of talks about, they kind of say that, in our system we have avenues for dealing with these problems. We have political solutions like voting, or like I think they say there is a statute that says that police officers that fail to apprehend, that officers are subject to criminal charges and a penalty of 2 years imprisonment for failure to arrest lawbreakers. But clearly that worked in this situation. So we have, like I said, you need to trust the political process, and you need to trust that these public servants will be held accountable by the political process. And we can't just have individual liability or individual recourse for these victims, because if we did, then we would open the floodgates to litigation. And would we sue the post office for failing to deliver a package on time? And I think that that's hyperbole, but it is just ridiculous, I think, because as we know, as voluntarists in the private sector, there are specific duties that would come into play. If you contract with a private security firm and they're negligent in answering your alarm that your shop is being broken into, and you have a personal contractual arrangement with them for them to protect your store, then you can sue the hell out of them. But you just because the police monopolizes just because the state monopolizes policing services, now it's a duty owed to the public in general and not to a specific individual. And like I was saying, if they're going to assume this as a practical matter, the court does have a point that we can't open the floodgates to litigation, but that is just so convenient for them. And meanwhile, people like the plaintiffs in this case are left holding the bag after being raped and tortured for so long because the police didn't do their jobs. And it's very frustrating. It's very infuriating here. But I got through the gist of the opinion. There's a bit towards the end. There's a dissent that's long. But he isn't making any kind of arguments that would be friendly to us. Let's see who wrote the dissent. Joined by Justice Kelly, Associate Judge, with whom Mack, Associate. So Kelly and Mack are the two judges dissenting, and they disagree with the facts and not the principle, just saying that in this instance, the plaintiffs there was a duty that was created because it wasn't a negative act. It was more of a positive act because by coming and by knocking on the door, they created duty to the individuals inside. I actually, honestly, I didn't really focus on the dissent because I knew just enough to know the arguments that they're making. But like I said, Warren v. District of Columbia, it is definitely a decision that we should make light of, make use of, and just to know that general fact that police do not owe you a duty to protect you. That's not their job. They owe it to the public in general, and that is, as the justices say here, that is a well-established principle within criminal law in the United States. And it's very frustrating, but it makes a lot of sense, I guess, within our certain sphere. But that is the truth of the matter. And I talk about this a bit in my domestic violence paper. That's kind of where I became familiar with this case because I cited it. like I said, in the next couple weeks here, I'm going to make a presentation, another video about my paper in general, has to do with domestic violence policing. But there's another case called Castle Rock v. Gonzalez that I think I've alluded to in the podcast before. That it was a restraining order that you would think created a special duty, but also the victim was left out of luck. The plaintiff was. But in the dissent, Justice Ruth Bader Ginsburg, because it was a Supreme Court case, specifically stated that if it was a private security firm who had undertaken the duty, a contract with the plaintiff, then the plaintiff would be able to sue the private security company if they were negligent, even in not acting. So take that for what it's worth. It was dicta and it wasn't holding opinion of the court, but her language was, surely there would be a actionable property interest there in the enforcement of that restraining order. If the victim had taken out a contract with a private security firm for the protection of her and her 3 daughters who were murdered because the police did not respond to her cries for help in enforcing the civil restraining order, the civil injunction. So like I said, I have this Warren v. District of Columbia opinion linked in the show notes page. You can find the show notes by navigating to libertyweekly.net/46. Also, I'm going to be publishing, probably right after I finish filming this video, my domestic violence paper in full with all the citations and everything for my Patreon supporters at patreon.com/libertyweekly. They support me every month with about $23 it is right now. They have allowed me to purchase this webcam so you can view me in all my glory. Wink, wink. But for real, I really appreciate all the support that I get from my Patreon subscribers, and really helps me do what I do here. And hopefully I'm looking forward to, like I said at the beginning of this podcast, really niching down and providing you with the kind of content that no one else is providing, which is legal analysis from a voluntarist perspective. I think there's a lot of utility in that. But I want to open the floor to my listeners and subscribers to send me court cases so that I can meet the demand that you guys have for legal analysis. If you want to know, maybe if you're farming the Nurse Wubbles case or instances of police misconduct, I can take a look at the opinions and explain to you maybe why the court ruled or thought a certain way, and probably why I think it was BS. But I think that would be a good thing to start doing. So other than that, I would urge you to subscribe, rate, and review me on iTunes, Google Play, or Stitcher. That really does help us out, really helps me get more exposure. Also, subscribe on YouTube and hit the bell button in the description of the video below. That way you can be informed and notified of all my new content that comes out through these channels. So once again, I really appreciate you joining me for another episode of the Liberty Weekly podcast, and I have a lot of really cool stuff planned in the coming weeks, and I would urge you to stay afoot. So thanks again. This has been Patrick McFarland. Have a great week, everyone.